background about myself. I am an attorney at Holby & Koenig. We're an IP boutique here in Philadelphia. Before becoming a lawyer, I was a software developer for a number of years. My practice relates pretty much, or for the most part, to patent prosecution in software and electrical engineering technologies. I have the privilege at Holby & Koenig of working with a number of leading international technology companies, as well as a number of Philadelphia startups. Speak up. And our office is right around the corner. So I'm going to give a pretty high-level overview of some IP topics as they relate to some things that startups deal with. But if I could deal with IP kind of in a vacuum, I'm going to speak to IP as it relates to a handful of topics that startups are going to be kind of working with and wrestling with as they ramp up. And specifically, I'm going to speak to IP as it relates to branding, technology, and then creative content, books, music, and movies and related content. So on the topic of branding, when a startup is initially ramping up, they're going to have to do some branding. They're going to figure out, what's our company name, what are we going to name our products, and engage in that sort of kind of dialogue and working through, what do they want the company to look like, how are they going to present themselves to the world. Those kinds of branding decisions should, of course, be based on their business goals. How do they see themselves as a company? What is it that they're doing as a company? What are the products that they're selling? That being said, these decisions should also, to an extent, be driven by trademark law. Because trademark law relates to the words, symbols, logos, and other related items that essentially distinguish a company in the marketplace from other companies. One example of this, if I were to want to establish a online music streaming service, I might initially be inclined to call my service the online music service. As it happens, in trademark law, there are some limitations as to the kind of names that you can use and have a valid trademark. So, for example, you can't pick a very generic term and have that be a valid trademark. In this example, online music service just wouldn't fly. You have to pick something that's a little bit more distinctive. So, if I were to choose something like Spotify, which is a word that was just created by the founders of the Spotify company, that is something that would be kind of received favorably in the trademark world. Going on to technology. So in the technology area, patents essentially cover technological inventions. If you obtain a patent on a particular technology, you have the ability to prevent others from using the technology that you have the patent on. It covers technologies from pharmaceuticals in the biotech space to mechanical inventions related to innovations in car engines to software inventions. As we see here, this diagram is a figure from a patent that is owned by Facebook. Mark Zuckerberg is an inventor on this patent, and what it covers is essentially the Facebook newsfeed that you see. Facebook having this patent, if there's any other kind of social networking site out there that tries to implement a feature similar to this, Facebook's patent will, in short, prevent them from doing so if Facebook is to assert it against them. There's kind of some limitations to patents, some challenges involved in obtaining patents. There's a good bit of costs involved, and the patent process can take quite a while. With respect to this Facebook patent, it issued in 2010. It was filed in 2006, so there's a 4-year window there. And it probably cost a good chunk of change for Facebook to get it through and ultimately get the patent. That being said, if you're working with a good patent attorney, there are ways to kind of defer costs and mitigate the initial ramp-up costs involved. Moving on to some content-related topics. So whenever you're dealing with creative content, movies, music, books, that kind of thing, copyright's in play. If you own the copyright in a creative work, you get to control the distribution of that work. So if your work's being sold in an online marketplace like iTunes or on Amazon.com, you're involved in that transaction in some way. Startups, depending on their nature, can have a number of different kind of copyright-related issues. And it really depends on how they're dealing with content. As one example, Spotify. They stream music. For this to work legally, they had to go out and essentially establish relationships with a number of different industry music labels, essentially the copyright holders and all the music that they wanted to stream. Pinterest, what's going on with them is that they have a site where users can upload content. One kind of concern in that area is, what do you do if users upload content that infringes someone else's copyright? There's a lot of law that's in play and that kind of thing, and to do this right, Pinterest had to look into that, the attorneys that they were using when ramping up, and put procedures in place and that kind of thing to make sure that they had everything set up right. Yelp, they're not a startup anymore. They did their IPO a few months back, but an interesting thing going on with them is whenever I post a review on Yelp, I initially, anyway, by the defaults involved in copyright law, own a copyright in that review. But that can be modified based on terms of service that Yelp provides that you have to agree to when you sign up for the site. So in establishing a site, Yelp had to think about things like, well, what if I want to, a couple years down the line, market a book that relates to the most clever reviews from 2011? Should I be able to take this user-generated content where the generators would initially own the copyright and kind of take it from them and kind of sell this book? Can I cut them out of that process? And that's something that they had to deal with and then figure out what they wanted to do with, and then they define that in their terms of service. Well, that being said, I very briefly touched on trademarks, copyright, and patents. I barely scratched the surface with respect to all of the different IP issues that a startup's going to want to look at. I've listed a couple more here. In the interest of time, I won't be able to go into any of them, but I just wanted to throw this list up to appreciate, so that everyone here would appreciate that there's really quite a lot that you want to kind of take a look at as you ramp up. And as a final couple comments and takeaways related to my previous slide, there's a lot going on in any kind of startup with respect to IP, and you're going to want to sit down with an IP attorney at the beginning, kind of figure out where you stand, and figure out what the issues that you might be facing might be, and essentially figure out what you want to do. That being said, a lot of times there can be costs involved in speaking with an attorney and working that all out. Here in town, we're fortunate enough that there are a number of attorneys who are very willing to sit down with startups and give strategic advice. You're probably unlikely to be able to find an attorney who's willing to, say, write a patent application for you for free, but I know there are a lot of practitioners in the IP community who are willing to sit down with startups and just kind of discuss things and hash things out. As one example, my firm does office hours at Seed Philly, where if anyone wants to come in and talk, we're there to talk. I know a number of other attorneys who do office hours at various other places. All they ask is that you kind of reserve beforehand, and then whatever you want to talk about, you come in and talk about. And then finally, given that IP can be really, really important to the ultimate outcome in the business, you want to make sure that you have these initial discussions and that you plan accordingly. As one example, if you're going to release a particular technological feature on your site to the public on date X, you want to speak with your patent attorney before doing so to make sure that if you need to file an application before that date, you go ahead and you get it on file, and that kind of thing, to make sure that your business and what you're trying to do in terms of the goals that you have line up with your